Hello there, and thank you for joining us for a Trustees podcast brought to you by the Illinois Community College Trustees Association. I am coming to you live from the Quad City campus of Black Hawk College, located in Moline, Illinois. And I'd like to thank Black Hawk College's Board of Trustees and Black Hawk College's marketing department for their time and resources in making this podcast possible today. And before we jump into our topic for today's podcast, I'd like to briefly introduce myself. My name is Allison Wright, and I am a partner and shareholder at the law firm of Pappas Wright PC, located in Rock Island, Illinois. Our firm focuses exclusively on management, labor, and employment matters and clients, and I lead our higher education law division, which means I have the distinct honor and privilege of working with trustees like you on a daily basis. But enough about me. Let's go ahead and dive into our first topic for today.
So we are here today, and you are watching this podcast today because you have been appointed and currently serve in an incredibly important role as a trustee for an Illinois community college. And as part of that role, you are expected to comply with various Illinois statutes and rules, one of which is the Illinois Open Meetings Act. As you know, every meeting of the Board of Trustees is governed by the Illinois Open Meetings Act. And depending on the type of communication that occurs between trustees, you may be surprised to know that Illinois law considers even an email or a conference call a meeting under OMA. So for this podcast, we will take a closer look at the Illinois Open Meetings Act as we dive into this segment entitled Oh Me, Oh My, OMA. So let's get started. The Illinois Open Meetings Act has many, many nuances, and we could spend considerable time on just portions of the statute, such as closed session meetings. But today we're going to talk about four main topics regarding the Illinois Open Meetings Act. First, what is it? Sure, it's an Illinois law, but what else should you as trustees know about it? Second, when does OMA apply? Who and what does it cover? And the third topic we will discuss is what I like to refer to as the QB rule. And no, it isn't a football regulation, but it will deal with QBs in the sense that we want to identify a rule to guide trustee communications that are compliant with OMA. And lastly, the fourth topic we're going to cover are some trustee takeaways, some general rules and guidelines that put OMA into practice for trustees as you navigate the various issues you will face as you govern your community college. So let's move right into our first topic, shall we? First and foremost, let's talk about what the Illinois Open Meetings Act actually is. As a trustee, as I mentioned, there's a myriad of rules, regulations, and statutes that you are going to be expected to know about and comply with. Things such as college policies, board policies, the Illinois Public Community College Act, and of course, one of those things is OMA. The Illinois Open Meetings Act governs meetings of public bodies in the state of Illinois, which includes meetings of trustees of our Illinois community colleges. The Open Meetings Act is a targeted piece of legislation, which has been in effect for almost 90 years, and its primary purpose is to keep meetings of public bodies open to the public. At that time, the General Assembly stated, as you see quoted on this slide in navy blue, "Of what avail is an open door to the public if the proceedings are secret? The eye can see, the ear can hear, but secrecy conceals all." Now, you will often hear the phrase sunshine laws apply to OMA. And the reason OMA is part of the Sunshine Law package is because the law is intended to shine the light on or bring transparency to public bodies conducting public business. So here you see a few of the main purposes listed on this slide. OMA is intended to provide people the right to be informed as to the conduct of public business, to require public bodies to vote in open meetings, to require public bodies to deliberate openly, and as a means of achieving that sunshine status, the Open Meetings Act has certain procedural requirements, such as advance notice and the right to attend all meetings, unless of course they are properly closed. But as a general rule, meetings under OMA are open to the public unless one of the exceptions applies. So who and what does OMA apply to? Well, in its most basic sense, OMA applies to public bodies and their meetings. Some definitions in OMA are short and sweet, and even though that may be the case, they have resulted in significant litigation as public bodies, or those suing them, argue over the specific meaning of a particular definition or word. But we'll start with an easy one. A public body is defined by OMA as all legislative, executive, administrative, or advisory bodies of the state, counties, townships, cities, villages, incorporated towns, school districts, and all other municipal corporations, boards, bureaus, commits, or commissions of the state, and any subsidiary bodies of any of those foregoing, including but not limited to committees and subcommittees. Now that sounds like a mouthful, and it is. But in short, what does it mean for ICCTA trustees? Well, it means that the definition of public bodies under OMA will apply to the Board of Trustees you serve on, any committees or subcommittees of that board, any other bodies of the college that may be required to convene from time to time, such as the Education Officers Electoral Board. So in essence, a public body means your board and the various subcommittees or bodies created by your board. Now we know that OMA applies, as I said on the last slide, to meetings of a public body. And I'm sure you're sitting there thinking that sounds really straightforward, and it is in a lot of ways. For example, the most traditional sense of the word meeting clearly applies to your regularly scheduled board meetings. But is that it? Are the events released on your annual board calendars the only ones that will qualify as a meeting under OMA? Well, let's take a little bit closer look at that definition. Section 1.02 of OMA defines a meeting as any gathering, whether in person or by video or audio conference, telephone call, electronic means, such as without limitation, emails, electronic chats, and instant messaging, or other means of contemporaneous interactive communication of a majority of a quorum of the members of a public body held for the purpose of discussing public business. Stated most simply, OMA defines a meeting as any gathering of a majority of a quorum held for the purpose of discussing public business. And because any gathering that meets this definition also carries with it significant responsibilities, such as posting notice and releasing an agenda which puts the public on sufficient notice of the business to be conducted, it is very important to understand the different ways trustees' conduct can trigger OMA. So working our way through that definition, a gathering includes, again, more than just your regularly scheduled board meetings. As defined by OMA, a gathering can include in-person, video, audio conferences, telephone calls, electronic means, including emails, chats, instant messages, text messages, and other means of contemporaneous interactive communication. This means that a gathering can refer to in-person discussions, emails, text messages between trustees, social media posts, virtual meetings such as Zoom, FaceTime, or Skype. And given the incredibly broad scope of its statutory definition, it is safe to assume that nearly all interactions will qualify as a gathering, meaning if you are communicating, you should assume it meets the first step in this meeting definition under OMA. So with that, as we work our way through the various elements of the definition, I would, as you can see on this slide, replace any gathering with any communication, so that the definition, rewritten, defines a meeting as any communication of a majority of a quorum held for the purpose of discussing public business. On the next line, we see the second component of that definition of a majority of a quorum. Now, this is one portion that is explicit and provides us with a black and white rule of operation. A quorum is a majority of the board. So to meet the threshold requirements for the definition of a meeting under OMA, we are talking again about any communication involving a quorum, which is a majority of a majority. So when we take a 7-member board under the Illinois Community College Act, if there are 7 members on the board, a quorum is 4, and that majority brings us to 3. So with that, we look back to the definition of a meeting and revise it again. The revised definition will read then, any communication between 3 or more trustees held for the purpose of discussing public business. And in turning to the last part, we note that there is a content distinction within the statute. This means that OMA does not apply to every communication between trustees as a blanket rule. Instead, it will only apply when the trustees are discussing specific information. So what does "for the purpose of discussing public business" mean under OMA? Well, looking back at the intent of OMA, we know that it is designed to prohibit secret deliberation and action on business which properly should be discussed in a public forum due to its potential impact on the public. And of course, the Illinois Attorney General's office has provided us with more information about what that exactly means. And how did the Attorney General's office do that? Well, it does that by and through its public access counselor, who issues opinions on violations of OMA and its documentary counterpart, the Freedom of Information Act, most commonly referred to as FOIA. And after litigation and complaints on OMA violations, we now know that a meeting for the purpose of discussion of public business does not apply to a meeting when there is no examining or weighing of reasons for or against a course of action, there is no exchange of facts preliminary to a decision, and there is no attempt to reach accord or agreement on a specific matter of public business. So where does that leave us? Well, we know that OMA does not apply to communications with two or less trustees. We know that OMA does not apply to communications that are not about public business. So what are some examples of that? Included here on this slide are some of the broadest categories for those exceptions. Social gatherings. If 3 or more trustees attend a wedding, for example, they're able to all be in attendance at the same time without triggering OMA so long as their communications remain at bay. Informational events or trainings. This includes items like ICCTA trainings, for example. If your entire board were to attend, so the ICCTA can provide more of their wonderful information with you and your fellow trustees, your whole board may attend the training at the same time, again without triggering OMA, so long as your conversations qualify with the QB rule we'll talk about soon. A third example are award ceremonies and graduations. These are another great example. Of course, among the many supportive faces students love to see are those of the board, and to have them in attendance showing support for the success of your students is a big deal. And in fact, if the whole board wanted to attend, their attendance would not trigger OMA because they are not getting together to do the 3 things we just talked about. They're not examining or weighing reasons for or against a course of action or exchanging facts preliminary to a decision, and they will not be attempting to reach agreement on a specific matter of public business.
So taking what we've talked about today with that original definition of a meeting under the Illinois Open Meetings Act, we know that the Illinois Open Meetings Act is going to apply to a gathering, which we know means any communication, including text messages, emails, or any communication that you're going to have with the majority of a quorum, which is 3 or more trustees, for the purpose of discussing college business. Now, there are plenty of other podcasts that will get into the more nuanced exceptions of the Illinois Open Meetings Act, and we'll focus on things like what is an open and convenient forum, so we won't talk about those today. But what I do want to talk about next is what we refer to in practice as the quarterback rule, or the QB rule, and it's a surefire way for trustees to be able to take the exceptions and the rules of the Illinois Open Meetings Act and know exactly when the Illinois Open Meetings Act is going to apply to your communications as a trustee.
Now, this does not mean that trustees cannot mention anything about the college without triggering OMA. As you see with the new operative definition here, to discuss college business or matters, they can still have conversations that don't trigger OMA. Taking the graduation ceremony as an example, 3 trustees could comment on the student's success and achievements without meeting that threshold requirement of discussing college business. Because while it pertains to the college, they're not examining or weighing reasons for a particular course of action, nor are they exchanging facts preliminary to any decision. And therefore, there is no basis to state that trustees would be attempting to reach agreement on a specific matter of public business by simply commenting during the graduation ceremony to one another. Now, like I said, there are many nuances within OMA, and there are other podcasts that will provide further detail on some of the more litigated or analyzed issues. But with OMA's operative definition in mind, we now turn to what I call the QB rule, which is a rule that can be applied to help any trustee navigate concerns about whether or not OMA applies to any particular communication. We know that gathering is a broad term, and it includes everything from large in-person meetings to private text messages exchanged between trustees. So as trustees find themselves engaging in communication, this trustee takeaway will help keep the OMA meeting standard in perspective. Now, we know that the quarterback of any team serves a very important role, just like you do as a trustee. In fact, a community college could not operate without its board of trustees. And because what you do and what you say as a trustee can implicate the college, you need to be able to navigate the X's and O's of all of your interactions that pertain to college business. So what is the QB rule? Well, it is simply a mnemonic device to help keep the rules at your fingertips. If you are looking at whether OMA applies to the communication you are engaging in, check to see if the QB rule is met. Looking at the Q, quorum requirements. Is there a majority of a quorum present? Meaning, is this communication involving 3 or more trustees? And looking to the B, are you talking about college business? If you answer yes to both of those questions, then OMA applies, along with all of the notice, agenda, and other procedural requirements that come into play. So as far as trustee takeaways, we have a few final slides to walk through. The first has to do with emails, which is quite possibly one of the most efficient forms of communication we know today. Especially in a world after COVID-19, email is likely the go-to method of communication for many. But for trustees, we know that email communications can actually violate OMA if they trigger the meeting definition and are not treated as a meeting at the time. So here, on this slide, I give an example of an email from the president of the community college to the board regarding an employee personnel matter. As stated on the slide, the email is sent directly to all board members, and it includes information regarding an employee issue that the president believes may result in litigation. At the end of the email, the president states, "We will discuss this at the next board meeting, so let me know your thoughts." Upon receipt, numerous trustees reply all and ask the president follow-up questions regarding the employee issue and what facts have been found thus far in the investigation. 2 trustees even state in their emails that they feel this will likely warrant termination of the employee at issue. So here, not a single trustee leaves the comfort of their home in order to engage in this discussion. Have they met the definition of a meeting under OMA? And the answer, if we use the QB rule, is there a majority of a quorum present? Well, yes, because the emails include the entire board. And are they discussing college business? And again, yes, because they are discussing and examining facts which could result in a particular course of action, such as disciplinary sanctions, which is actually discussed by 2 trustees in their reply. So with that, we know that this email chain violates OMA because it does not comply with all of the requirements of the Open Meeting Act. And as for some trustee takeaways, using the QB rule will help you evaluate those communications to see if it applies. If you can answer no to both questions on the QB rule, then OMA does not apply. And as far as tips for sending emails, what do we know about the current state of OMA under Illinois law? Well, as a general rule, avoid emails that include 3 or more trustees. If you want to send an email to everyone on the board, blind copy all recipients so you can eliminate the possibility that someone will either intentionally or even accidentally reply all and include everyone on their response. When communicating, use an explicit directive to respond only to you or to a designee. For example, please respond separately to the board secretary with your response. If you are sending an email that is not seeking a response, you may send it to 3 or more trustees because in the absence of deliberating or discussing college business, you can avoid the OMA definition. If you go that route, I would recommend stating that you are not seeking a response or simply state, please do not respond to this email as a reminder, again, to your fellow trustees to avoid reply all or other forwarding errors. Now, another hot topic that has come up in recent years is the use of social media and the possibility that social media posts can become a platform that actually violates OMA. As for some general rules, again, utilize the QB rule. If you are posting about college business in a public forum and your post is analyzing facts or contemplating actions of the college or by the board, be cognizant of the fact that your post could turn into a deliberation or a meeting under OMA if your fellow trustees participate as well. So as a general rule to avoid these problems, you can refrain from posting about college business on a forum that allows for comments and responses. And in addition to posting, Commenting on other posts or articles online runs the same risk. If 3 or more trustees all participate in commenting, and depending on the nature of the communications and how those communications go, you could run the risk of transforming that post into a meeting under OMA. So, as for some general trustee takeaways on the OMA topics we covered today, I'll leave you with these 10 tips. Make sure you understand the scope of OMA. Remember the definitions of public bodies and the fact that OMA applies to even subcommittees of your board. Remember, OMA applies to all forms of communications and discussions. Do not think of a meeting in its traditional sense only, in that once a month in a boardroom sense. Remember that under OMA, even emails or text messages can constitute a meeting under the Act. Use the QB rule at any time to evaluate your communications. Focus on who is a part of the communication and what you are talking about. If you have 3 or more trustees and you're discussing college business, act appropriately. Even unrelated conversations in looking at number 4 can transition to college business or issues involving the college or the board. So be cognizant about what you are talking about when you engage in communications. And to that end, for number 5, put a stop to conversation detours. If a conversation goes from something not covered by OMA and transitions into something related to college business, act appropriately. End the conversation, change the subject, or leave. And be aware of the public's perception. Now, this one is really important because everyone knows that it costs money to defend even the worst of lawsuits. And it costs money for your legal counsel to respond to an OMA complaint with the Illinois Attorney General's Public Access Bureau. So if you or your fellow trustees engage in conduct that may even have the appearance of violating OMA, be aware of the risk that comes with that. Now, the easiest example of this is trustees meeting together for dinner prior to or directly after a board meeting. If the entire board meets together publicly, it could have the perception from a distance of meeting the QB rule and therefore constituting a meeting under OMA. So be aware of your surroundings and take appropriate measures to ensure you limit your exposure in that regard to the extent possible. Now, for number 7, be diligent with those necessary strategies. As a trustee, you have a very, very important role in the state of Illinois and for your community college particularly. So be diligent about the necessary steps and strategies necessary to comply with OMA. When in doubt, take yourself out. As part of that, to the extent you are ever concerned a communication has crossed the line, maybe detoured into college business, I would recommend that when you are in doubt, take yourself out. Leave the conversation if you're at a party and the conversation goes in a specific direction. Sometimes it's necessary to discuss sensitive information among trustees outside of a board meeting, and that's completely fine, so long as you don't reach the 3 trustee threshold. For number 9, this comes into play here a bit too, that sometimes you do need to disseminate sensitive information to everyone. And if your board has a set standard on communications and you utilize your chair to get that information out to everyone, and your chair follows the email tips from before, you can avoid soliciting responses or engaging in an analysis of facts or outcomes, so your chair can serve as a great resource for consistency to ensure information is delivered as necessary and in a timely manner, but also, and maybe most importantly, in compliance with OMA. Now, lastly, I would recommend that you stay current on Illinois OMA cases and public access counselor opinion updates. Utilize the wonderful resources you have like ICCTA to stay current on Illinois OMA cases and those counselor opinions. In 2020, the Illinois Public Access Counselor issued 10 opinions on both FOIA and OMA. There has already been one issued thus far for FOIA for 2021. Some are very fact-specific issues, but many include general interpretations of OMA which help define the way in which trustees should continue to act to achieve compliance. Now, as I said before, there's a lot of information about Illinois' sunshine laws, which include FOIA and OMA, and I will be presenting numerous other podcasts on additional topics which will be available through ICCTA.
So now we've discussed the Illinois Open Meetings Act, when it applies to you, and we've talked about the QB rule, so you know as a trustee exactly what communications you're having and when the Illinois Open Meetings Act is going to apply to you in your day-to-day operations. If you have any further questions, you of course have the wonderful resource of the Illinois Community College Trustees Association, and you may also reach out to me directly if you have any questions about today's podcast. Thank you for your time.